Good morning, Mr. Martin. Can you hear me? You're muted. Now calling case number 23S00425. This is the state of Michigan versus Eric Martin. Can I have appearances for the record, please?
Stephanie Cannon with the Washtenaw Public Defender's Office on behalf of Mr. Martin, who is present, Your Honor.
Okay, thank you. Mr. Martin, can you please state your name for the record?
Capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N.
Before we even step foot into Magistrate Bray's courtroom, let's set the stage, because this case is a perfect snapshot of what happens when sovereign citizen ideology collides head-on with reality. Today's defendant, Eric Martin, isn't new to the Michigan court system. In fact, he's become almost infamous for showing up, talking endlessly, and somehow insisting that none of it applies to him. This time, however, the stakes are higher. He's not here for a routine hearing. He's being arraigned on a failure to appear charge after skipping not one, but two court dates in front of Judge Washington. And here's the twist. While this hearing is short, it's packed with consequences. There's an active bench warrant involved, revoked driving privileges, and a court that has clearly run out of patience. As you watch this unfold, pay close attention to how the magistrate keeps control, how Martin tries to derail the process, and how quickly the court shuts it down. Because this isn't just about courtroom drama. It's about accountability finally catching up.
Okay, thank you, sir. Today is the date and time set for an arraignment in this matter. What I am seeing is that you failed to appear for a court date on February 1st, and that you failed to appear for another court date on March 14th. Therefore, a bench warrant did issue for your arrest. Do you understand?
No, I do not understand, and I do not stand under the charges. I am one of the sovereign living people.
Okay, sir, I'm not asking you if you agree with me. I am asking if you understand the words that I just said to you.
Well, I do not understand. I might comprehend that I do not understand and that I do not stand under the charges. And I am not a defendant. I am a living human sovereign. I'm not the legal fiction corporate entity, all capital letter name.
Attorney
I do not accept an attorney.
Thank you, Your Honor. At this time, he would stay on mute and ask for a PR bond.
Objection. You're not speaking for me.
Right here is where the sovereign citizen playbook opens to page 1, the name ritual. Notice how Martin spells out each letter, carefully identifying which ones are capitalized and which ones aren't. To him, this isn't just spelling, it's a legal strategy. Sovereign citizens believe that an all-caps name represents a fictional corporate entity created by the government, while their so-called living man exists separately and is immune to court authority. The problem? Courts have rejected this argument for decades. Judges don't capitalize names to assert ownership. They do it for consistency and clarity in legal records. This moment perfectly highlights the disconnect between sovereign ideology and actual law. Martin thinks he's asserting control, but from the court's perspective, he's already identified himself on the record. And that means jurisdiction is established whether he likes it or not.
I think you're my attorney.
Thank you for the attempt, Attorney Cannon. You can turn your camera off.
Thank you, Your Honor.
Okay, Mr. Martin. At this time, I am seeing that your license has been revoked. You have failed to appear for court dates in front of Judge Washington. You were to have a sentencing hearing and a pretrial date in front of her, so that is what I am going to set you for now.
I need you to repeat to me again the case number of this case. Couldn't get it all when you said it first time.
The case number is 23S00425.
23S00
4.
Hold on. 23S00, right?
Correct.
Okay, after that, what else?
4.
Okay.
2
Yeah,
5.
was that it?
Yes.
Yes, 00425. All right. That
Okay.
wasn't finished. Cut me off. I
Okay.
had more to say.
Sir, I
You're
am
cutting
setting
me.
you for another. Yes, I am, because what I am doing today is arraigning you, and I am setting you for another court date in front of Judge Washington. That court date will be April 11th, 2024. That will be at 9 a.m. That will be for your pretrial and potentially your sentencing.
I can't remember all this at once.
This exchange is one of the most telling moments of the entire hearing. When the magistrate asks a simple question, whether Martin understands that he failed to appear, he immediately pivots into wordplay. I do not understand. I do not stand under. This is a classic sovereign citizen maneuver designed to stall proceedings and muddy the record. But notice how the judge responds. She doesn't debate philosophy. She refocuses on comprehension. Courts don't care whether a defendant agrees with the charges. They care whether the defendant understands what's being said. And Martin clearly does. He responds, he argues, he objects. All of that demonstrates comprehension. Ironically, the more he talks, the more he proves the court's point. This tactic might sound clever online, but inside a courtroom, it only reinforces the case against him.
She just wants to know if he understands what she said, not whether he agrees.
The date is when again?
April
Yep,
11th,
yep.
9 a.m.
All right.
That is 9 in the morning.
Okay. Got that. What else?
It will be over Zoom, like this hearing.
Right. Okay, now. Okay, is that it for that? Okay, now. Let me ask, so does she call herself, is this a separate charge?
Here's where things take a turn that actually works against Martin in a serious way. When his public defender attempts to speak on his behalf, requesting a PR bond and standing mute, he immediately objects. Sovereign citizens often reject attorneys because they believe lawyers are agents of the state. But what they don't seem to grasp is that refusing counsel doesn't give them more power. It removes a critical layer of protection. His attorney was trying to limit damage, preserve his rights, and keep the hearing procedural. By shutting that down, Martin isolates himself entirely. The court now deals with him directly, and that means every word he says goes straight onto the record. No filter, no strategy, no safeguard. This isn't independence, it's self-sabotage.
I'm not
The failure
entirely
to-
sure what you're asking. So what happened here was that a bench warrant was issued for your failure to appear. At this time, to guarantee your appearance at the court date on April 11th at 9 a.m., that warrant will continue.
Okay, that wasn't intentional, so that's why it's baseless. It's baseless, and it shouldn't have been a warrant issue because
Okay, sir, you've got your next court date. That's April 11th at 9 a.m. The bench warrant is continued. This hearing is concluded, and you are free to sign out of Zoom.
So I have more to say. I'm not done saying what I have to say pursuant to my First Amendment right. I have more to say here. That is,
This is the moment where consequences start to crystallize. The magistrate lays out the timeline, revoked license, missed court dates, and an upcoming sentencing that never happened because Martin didn't show. Failure to appear isn't a technicality, it's a serious violation. Courts rely on compliance to function. When someone repeatedly ignores scheduled appearances, judges don't see misunderstanding, they see avoidance. And here's the key detail, the court isn't debating guilt today. This hearing is about ensuring he shows up next time. That's why the bench warrant matters so much. It's no longer about persuasion, it's about enforcement. When Martin claims he can't remember all this at once, the magistrate's response is subtle but firm. Courts operate on personal responsibility. Remembering a single date and time is not an unreasonable expectation, especially after multiple failures to appear. This isn't about confusion, it's about pattern. And that pattern tells the court exactly what it needs to know. Judges don't escalate warrants because they want to. They do it because the defendant has demonstrated that lesser measures don't work. This exchange shows the court drawing a line. Compliance is no longer optional. This is the quiet but powerful turning point of the hearing. The magistrate makes it clear the bench warrant isn't going away. Even though Martin insists his absence wasn't intentional, intent doesn't erase impact. The warrant exists to guarantee his appearance, not to punish him emotionally. From this moment forward, any law enforcement interaction could end with him in custody. That's the real-world consequence of ignoring court authority. The court has shifted from trust to control, and that's not something easily reversed. And that's how this hearing ends, not with a dramatic argument, but with decisive authority. The bench warrant stands, the next court date is locked in, and the court refuses to indulge any further theatrics. This case perfectly demonstrates why sovereign citizen tactics fail in real courtrooms. Wordplay doesn't erase jurisdiction. Talking doesn't equal control. And rejecting the process only accelerates consequences. Eric Martin now faces a future where compliance is no longer optional, and the margin for error is gone. If you found this case as shocking or satisfying, as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because if there's one thing the courts have proven time and time again, it's that reality always wins.